And this is actually, I think, a time for a PCC and your motion to withdraw.
Yes, sir.
All right, go ahead with your motion to withdraw.
Welcome to another gripping session inside Judge Simpson's courtroom, where tension, confusion, and financial frustration collide. Today's hearing begins with a defense attorney trying to withdraw from a case, a move that instantly raises eyebrows. Why now? What pressure could drive a lawyer to walk away before a probable cause hearing even begins? This isn't a quiet civil dispute. It's a capital-level case where lives and futures hang on every payment, every word, every delay. Watch how Judge Simpson keeps control as the defense cites financial hardship, while the defendant fights to keep representation. We'll break down each motion, every objection, and the real-world law behind attorney withdrawals. Keep your focus. Each minute reveals another crack in this professional relationship. And ask yourself, when money meets justice, who deserves sympathy? The lawyer seeking fair pay or the client pleading for help?
Your Honor, I put most of the important facts that I think that are necessary. If the court wants details, I'm more than happy. But I believe based on the rules, if I have a financial hardship and continued representation, the court would take that as a reason for withdrawal. But more importantly, if I can withdraw at a time which will not create any kind of substantial hardship on behalf of the defendant, and I think that would be the case here. We do have all the discovery that we think we're entitled to at this time, but we have not had a preliminary exam, and I don't believe that any of my clients' rights have been prejudiced.
And Ms. Johnson-Jackson, anything you want to say regarding Mr. Mullins' motion to withdraw?
Yes, I don't agree with it.
Pardon?
I don't agree with it.
Okay, what don't you agree with?
Based off the that was provided to me in reference to, can I see your paper?
Absolutely.
The one that's under,
Oh.
it's in there, like, way down. The email that you sent me this morning.
You want the motion? You want the? Didn't you read me something?
Yeah, that's what I'm talking about, the email that was.
Hang on.
Thank you.
Mm-hmm.
So this morning, the email that was sent, which is what I'm about to read, it says the defense counsel appear on behalf of the defendant with the understanding that defendant will be remitting forthwith to defendant counsel a retainer payment as agreed upon by defense counsel and defendant. The second one was defendant subsequently failed to remit said retainer payment, nor has defendant indicated when the retainer will be paid. 1 second.
As she reads the motion, pay attention to the specific language. Failure to remit retainer, failure to fulfill obligation. Those phrases sound dry, but they carry heavy meaning. Retainers are the backbone of attorney-client contracts. Without them, the attorney can't continue ethically or financially. The judge's job here is to confirm whether this withdrawal causes substantial hardship. If not, permission to withdraw is often granted. Notice the defendant's confusion. She admits payment issues but also insists on misunderstanding. That fog of communication is lethal in law. Misaligned expectations can collapse a defense faster than a bad verdict.
The third one is an attorney may withdraw if his client fails substantially to fulfill an obligation to the lawyer regarding the lawyer services and has given reasonable warning that the lawyer will withdraw unless the obligation is fulfilled. So in reference to all that, in reference to all that stated, the retainer, so him and I, it seems like there is confusion between him and I in reference to the retainer fee and just like the distance of my case. Does that make sense?
No.
So I don't agree. So what he's doing is a motion, right?
It's a motion to withdraw. It's your counsel.
Right. So I don't agree with the motion to withdraw in reference to this is my probable cause hearing, right?
Well, it is a probable cause hearing, yes.
Right. So Okay, so I have a question. So with him withdrawing as my counsel, are we still doing this today or is that postponed?
If he withdraws, okay, ma'am. So I have to make a determination as to whether or not there are grounds to withdraw as
Understood.
I'm looking at it. So I asked, Mr. Mullins stated his position. I have the motion in front of me, and I'm asking what your position on this motion to withdraw is.
Oh, I absolutely disagree. And to my understanding, it seems like most of like videos and just maybe more statements have been given to my defense, but to my understanding, that is the discovery, but I don't know anything about it because him and I haven't spoke about it. Does that make sense?
Okay, it could, yes.
Okay.
So, ma'am, let me just ask you this. His basis of withdrawing is that you were supposed to, you had certain financial obligations. It's indicating that you haven't fulfilled those. I don't need to know what those specific terms are because it's not relevant to at least the court's determination at this point. Are you indicating to me that you did fulfill those obligations? And therefore, okay, but fully fulfill those obligations?
Here, Judge Simpson cuts to the essence. No emotions, just accountability. Did she pay or not? It's a surgical question, and her hesitant reply, I have put money in his hand, doesn't meet the standard. In law, partial payment doesn't equal fulfillment unless specified. The courtroom rhythm changes. The judge senses contradiction, and even Mr. Marin's tone tightens. He appreciates small payments but highlights a breach of trust. Viewers, think about this. Is partial effort better than none when someone's facing prison? Or does justice demand full compliance?
I haven't fully fulfilled obligations, but I have put money in his hand. So that's why, yes.
Okay.
Jenna, may I respond just, or do you want me just to be quiet?
Go ahead.
Yeah, she's right. She's paid me some money, of course. But the reality of it is it's less than a third of what the retainer understanding was in agreement for this case. In addition to that, I haven't paid anything in almost 3 months. There's been no efforts to pay me. I've had multiple meetings. I had a meeting on the 26th of June specifically to make this a focus. I don't like talking about money. I'd rather work as a lawyer and do the work on the case and have those meetings. But as you know, it becomes a conflict of interest when you're not being paid. This is a capital case. She's entitled to substantial work on this case as it being a capital case. And when I'm not getting paid, I don't know how I'll be able to do it. This is not like an OWI where even if I'm not getting paid, I could probably suffer through it and it wouldn't damage my practice or my mental health. This would be maybe a little more of a different of a situation. But to say that she hasn't paid me any money,
I don't think that you said that.
I just want to make it clear she has, but she has not even come.
That's not what I got from this. I get it. So, ma'am, are you telling me? I understand that you've paid part of what's there.
Yes.
Okay. But you haven't paid what the entire amount agreed upon was.
You said what the entire amount?
What the entire amount. You haven't paid that.
I haven't paid the entire amount.
Okay. So are you telling me that you're going to?
What I'm saying is there has been some confusion in reference to the amounts. There has been efforts, multiple efforts to make payment, and I have made payment. I have not made the entire amount. But
so let me just ask you this. As to the entire amount that was requested to obtain of the retention, why hasn't the full amount been paid?
Confusion meets contradiction. She says there was misunderstanding over the amount, while the lawyer says she drafted her own payment plan and ignored it. That detail crushes her defense. A client-proposed plan signals responsibility. Failure to follow it signals unreliability. Legally, this strengthens counsel's withdrawal request. The judge's facial stillness hides irritation. Efficiency matters, and wasted time in capital cases equals risk. Imagine sitting in that chair, hearing your own payment excuses dissected under oath. Would you defend yourself or freeze under that pressure?
Because there was confusion on the full amount.
Your Honor, Ms.
I don't know what that means.
Miss Johnson Jackson wrote me out a payment schedule. This was her schedule. It wasn't my proposed schedule.
Yeah.
She wrote me out a payment schedule and provided it to me and has not even lived up to that. And like I said, less than a third of the retainer in the case. And just so this court knows why I'm a little nervous on top of it is, and I explained this to her, I have a bifurcated billing system. Part of it's a retainer, that's a flat fee. The other part is an hourly when we get into motions and trial. And the fact that we're having such an issue with just the base retainer, I'm nervous. We go further in this case. We get into trial, we're going to have an hourly bill that's going to be accumulating, and I don't have confidence in that bill being paid timely. So hence the motion.
Ma'am, is he right? You laid out an agreement that you were going to pay?
We did have an agreement,
Ma'am, can I ask you why you just don't answer my question?
because
I think my questions are rather simple. Mr. Mullins has indicated you laid out a payment schedule to him. Is that right?
yes, but it wasn't the total amount being asked. The payment plan that was laid out was not the total amount that is requested. And so when I understand, when I say that there is confusion in reference to it, usually, for instance, people will sign a retainer fee with the lawyer, and that didn't happen. So once again, I did give him money to counsel me. But as far as the total amount, it wasn't.
Then ma'am, explain to me something.
Mhm,
If you haven't done that part,
mhm.
why shouldn't I grant his motion and just let him withdraw?
Now the drama peaks. The judge's question is blunt, almost rhetorical. This is the courtroom equivalent of a checkmate move. When a judge asks why not to grant withdrawal, the burden flips to the defendant to justify continuation. Her answer, linking withdrawal to probable cause timing, shows panic, not strategy. Simpson, steady as ever, ensures she won't be left unrepresented, hinting a public defender will step in. The takeaway: courts protect fairness even when personal finances fail. Still, does assigning a public defender instantly fix trust or reset chaos?
Because this is the probable cause hearing.
Because what?
This is the probable cause hearing.
Okay, and I give you another probable cause hearing. You won't be in any worse position
Mm. Okay,
because that's his obligation. His obligation is not to put you in a worse position when he goes to withdraw. And so that you understand what Mr. Mullins is really saying, and maybe he says it just more fancy way than I would. He doesn't want to get to the point where either you're not paying him or something else happens in the case, and then he's either stuck because he can't have you in a safe spot, or he just has to try to get out to save himself, and you're going to be in a worse spot.
I understand.
So can you tell me a reason why I shouldn't let him out?
So I have a question. Can I ask a question?
Sure.
So let's say that you rule that he in his favor. So I would be given a.
Ma'am, let me stop. I'm going to tell you what I'm going to do. Okay? And that way we can just put this to an end. I'm going to grant his motion to withdraw. I get it. I think you're a little bit worried that you're going to be left out there on your own. Here's PCC and whatever. Doesn't work that way here. So I'm going to grant Mr. Mullins' motion. Mr. Mullins is withdrawing from the case and further discharge of any obligation of this client or the court on this matter.
Decision delivered. Judge Simpson moves swiftly, granting withdrawal and transferring representation to the public defender. No drama, no delay, just order restored. Notice the language. You still have counsel, very capable counsel. It's reassurance wrapped in authority. For viewers, this is a masterclass in courtroom control. Judges juggle empathy and efficiency. Too much of either breaks justice. The defendant's sigh signals both relief and confusion. Who really wins here? The lawyer freed from stress or the defendant starting over? Share your thoughts below.
Thank you, Your Honor.
This now becomes a public defender case. You're represented by the public defender at this juncture, okay? That way you still have counsel, very capable counsel to represent you in this matter. Ms. Anderson. Thank you.
Thank you, Your Honor. First Assistant Public Defender Kalina Anderson with and on behalf of Ms. Johnson Jackson. Your Honor, I asked for a couple weeks adjournment for us to get discovery and speak with her about the case.
All right. Probable cause conference in this matter will be adjourned to July 25th, 2024 at 9 a.m. or as your invite indicates. Okay? Ms. Johnson Jackson, you understand?
Yes.
Okay, so you've got counsel now. They'll get the discovery. They'll be able to go through it with you and pace through it. It doesn't mean if you want to hire another attorney or somebody else, you can still do that. But you've got very, very capable, extraordinary counsel to represent you. So,
I understand.
okay. And so bond will continue.
Thank you, Your Honor.
Thank you.
Oh, okay. Mr. Kittle. I thought that was it.
We're ready. Oh. We've been ready for the last hour. And then the judge came charging out the bench. Jack Hill. All right, Gordon, let's call the case.
Your Honor, I am aware of the A bond violation. I did discuss it with the Tether agent. When the court's ready.
Okay, go ahead.
Okay, Your Honor, I'm aware that there was a violation, an alleged violation, that he was in the exclusion zone.
The hearing shifts. A new case, new stakes, bond violation, and tether tampering. Same judge, same calm authority, but a completely different tension. The defendant's story? A comedy of errors, cutting a hole in his pants for comfort that sliced his tether. The prosecution sees manipulation. The defense calls it accident. Here, forensic logic meets human absurdity. Legally, intent defines violation. Did he mean to cut it? The judge's questioning style corners him politely but firmly. Watch how Simpson uses sarcasm like a scalpel, forcing clarity without anger.
In that situation, Your Honor, my client contacted me, said he wanted to get some property from the location where he was excluded. I told him he could do a civil standby. Civil standby. He did contact the police. He went to a location, waiting for the police to arrive. And before the police arrived, the Tether people apparently violated him.
Well, there's that issue, but then I also have tether strap was cut.
It wasn't cut, Your Honor. It was damaged. He had the tether on when the agents arrived, and it was replaced, and he still has it on.
But it was split from the bottom. Why was that?
He was doing something with his pants, Your Honor, and may have accidentally done it, but it was not intentional. In fact, and as I said, he was on when they got there.
I get that, but what could he have been doing with his pants that caused the tether strap to split?
I was trying to cut a hole around it for more comfort on my ankle, and I accidentally
Cut a hole around
my
what?
pants. Put a hole in my pants so I can get more comfort.
He was trying to cut around the tether.
Trying to cut around it, but now I just put my pants through it instead of going over it. And I accidentally cut the tether on accident when I was cutting a hole in my pants, trying to cut around it. This part. It wasn't like I was trying to cut it off or nothing. It wasn't that.
You were trying to cut a hole around the tether and you
More comfort.
cut the strap.
Just
Well,
a-
it didn't,
it
well,
was-
Your Honor, you say
Oh,
cut. There was damage to the strap, but it wasn't cut off.
Okay, if you want to play word games, I'll play word games. I'm looking at the report. It was split from the bottom, so it was cut.
Yes.
It wasn't cut off. I get it, or it didn't come off of his leg. I'm just trying to figure out how you cut the strap when trying to cut a hole in your pants.
The knife went too deep. Now I'm holding my hands over it. It went too deep. I was cut all around it. And
You're cutting with a knife?
I used a knife to cut a hole in my pants. I wasn't trying to cut it off though. That was not my intention.
Any response from the people?
Well, I mean, I'm obviously concerned, and then he went past the victim's residence twice. I understand that saying is because he wanted to get a civil standby, but he should work that out first and contact the Tether agency before he did that. I mean, this is a domestic violence case. We had requested a $50,000 bond to begin with, and we were denied that at the original arraignment. So there's concerns with the tampering of the Tether and also its whereabouts.
Well, is there an indication that the civil standby was called for?
Yes.
I don't have any of the information.
We can get that from the police department, Your Honor. Which one?
Yes.
Who did he call?
Uh,
The sheriff's department?
Sheriff's Department. And it was Ann Arbor though.
Pardon?
It was Ann Arbor. I called Ann Arbor.
Which department did you call?
The sheriff's. The non-emergency line.
Okay, the Ann Arbor Police and the Sheriff's Department are two different agencies.
It was the police though.
The Ann Arbor Police?
Yes.
So you called the Ann Arbor Police Department? got a
Yes,
civil
before I
standby.
left. Before I came out here, I did that.
What?
Yes, before I left out from my house, I did call.
Now the debate turns digital. A phone call log becomes the centerpiece of defense. Did he truly arrange a civil standby or fabricate it after the fact? Modern justice often pivots on small data, timestamps, call records, text confirmations. Simpson wants proof, not storytelling. The defendant insists he called. Prosecution says no record exists. Think about this irony. Technology meant to protect him might save or sink him. Would you trust phone evidence to clear you, knowing one missing log could destroy your case?
I made that call before I left. And they told me to just give them a call when I get to Ann Arbor.
It comes from Flint, Your Honor.
Yes, I don't stay out there.
And did you call them?
Yes.
What date?
Whatever the date of the violation is, Your Honor. It all happened in one day.
So the Tether cut was on the 28th at 1:34 a.m. Then the next day on the 29th at 7:30, they received a call that the defendant was in the exclusion zone, the monitoring center. The defendant drove through the exclusion zone, passing the victim's residence twice. Once the defendant became stationary, they contacted Washington County Metro Dispatch and they arrested him.
Now, Your Honor, I realize there's
Hold
an
it. No,
exclusion.
no, hold it. I get that, but if he's got a civil standby and he's telling me he called the county, the moment Metro Dispatch is called, they're going to know that he's there. I need proof that there was a call for a civil standby because my problem right now is I've got what appears to be a tether tamper on the 28th, and then I have him in the zone on the 29th.
With the tether on, Your Honor.
Yes, I had it.
Okay, I'm still not understanding this whole knife thing, but he's in the exclusion zone and I don't have proof of a civil standby because that usually will appear very quickly. There would not be a violation file.
Your Honor,
So I'll tell you what, I'll pass the matter. Somebody needs to you guys need to get over to the sheriff's department, get that information on the civil standby, and I'll call it back up. But if I don't have proof of the civil standby, then we're gonna have a problem.
all right, thank you.
Go back to.
Yeah, his light's on.
Yeah, I know, you know, this, you know, okay, hang on. There we go.
How many people does it take to turn off a light on the phone?
Okay,
Three.
thanks, man.
Okay.
Your Honor, in the interim, my client showed me on his phone log, confirming that on the June 29th at 2:20 PM, he did make a call to the Ann Arbor Police Department. He called them this morning. They gave him oral confirmation that the call was received. He has now put in a FOIA request. They won't give him a written confirmation without a FOIA request, and he did file the FOIA request this morning. But I can show the court on his phone where the call, in the call log, where that call was made.
You're wanting to set for exam.
Yes, Your Honor.
All right. Here's what I'm gonna do. I will set it for a preliminary exam. With regard to the bond violations, I'll let the court handle any potential bond violations. He's got a new thing on the Tether, right?
Yes, Your Honor.
Did you get all of your property or whatever you were looking for that date? So there's no reason whatsoever for you to be back in that area?
No.
Preliminary examination will be set 30th, 2024, 9 a.m. before
Fresh hour.
Judge Freshour.
Thank you, Your Honor.
Case closed. For now. Judge Simpson wraps both matters cleanly. Withdrawal granted, Tether violation set for examination. Efficiency defines his bench. The broader lesson is universal. Courtrooms balance truth, trust, and timing. Payment disputes, device tampering, or missed communication all lead back to one question: accountability. In law, clarity isn't optional, it's survival. For viewers, this case reveals how quickly order can unravel when money, emotion, and law collide. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.